Hello, good afternoon. Okay, welcome to our lunch and learn session. Okay, I hope you have had your good lunch already. Okay, let me just clarify before we start. Okay, supposedly these sessions, okay, I will try to share on corporate cases, okay, company law and corporate law cases. But for this round, there is not really a suitable one that I can find. It's either on the AGMs, okay, power of directors to call for AGMs, those issues that we have already discussed in earlier case studies. So I picked this one, okay. This involves not only the law on judicial review, but it also touches on Societies Act, okay, which I think our firm deals with Societies Act, societies matters, and also public charitable trusts. Okay, so hope you'll benefit from it. And if there's any questions, do ask, okay, at the end of the sessions later. All right, so we shall start. This case is Chin Chi Kao, okay, as secretary of the Liam Hut Tong Cho Seng Tuan Association. Okay, it's a long name, so we will refer that to as the association, okay, against Peguam Negara Malaysia, the AG. So it's a Court of Appeal decision. Next. Okay, let's go to the facts of the case. There's this testator named Chia Leong Kian, leaving a will dated 6 May 1941 and a trust deed. Okay, so under the trust deed, okay, there's pieces of land and cash, okay, for the construction of a pagoda on the land to be used for benefit of Buddhist devotees, okay, and to conduct Buddhist religious customs. So it's for the community at large. So after the death of the testator, the original trustees, okay, failed to carry out the building of the pagoda, okay, and while the money has been used up. So on August 20, 1982, there was a court order, okay, declaring the lands to be a public charitable trust, okay, according to the principle of Cyprus Doctrine. Okay, they applied the principle of Cyprus Doctrine. So before we go further, okay, what is this Cyprus Doctrine about? Next slide, please. Okay, this doctrine is used to distribute, okay, settlement funds, okay, which began in 1986. Okay, long time already, this doctrine, so that the unused funds, okay, could flow to the next best beneficiary. Because this word Cyprus is a Latin word, originate from Latin word, it means as near as possible. So it's a legal concept that gives court the power to interpret the terms of a will or a gift, okay, nearest to the meaning of the testator, okay, the testator's will, okay, testator's intention, okay. So it's mostly used to interpret charitable trust, whether that trust is a charitable trust, public trust or not. So the court will usually use this principle, okay, apply this principle to make that declaration. Right, so we continue with the facts. Next slide, please. Okay, before that. Before this, yes. So with the order, okay, the lands were now vested in the names of the existing trustees. Okay, trustees, as we know, okay, 4 trustees. Actually, for public interest, public charitable trust, it can be more. Okay, but for private trust, it can only exist to 4. Okay, maximum 4. But for existing, it can be more than 4 lah. For public trust, it can be more than 4. Okay, but again, this existing trustee did not develop the land. Okay, never built the pagoda. So there's this association. Okay, very long name. Okay, Liam Hut Tong Cho Seng Tuan Association. Okay, we shall refer that to as the association. It happens to have followers of Buddhist faith, okay, and they are followers who worship this deity, but they have no proper place to carry out their worship and function. So of course, okay, then they need to seek funding lah, okay, from third party. So this association go and seek for funding. Okay, there was a funder. Okay, there was funder, but the condition for the funds to be given out is this association needs to be made a trustee. So it has the locus to execute agreements on behalf of the trust. Next slide, please. Okay, so the association then wrote to the Attorney General pursuant to Section 9 of the Government Proceedings Act for the AG's consent, okay, to either add this association or replace the existing trustee with this association, okay, either add or replace. And then the AG refused to give consent for either add or replace. Also, AG refused. So what happened next is that the association naturally will file a judicial review against the decision of the AG, okay, to ask for certiorari and mandamus against the refusal of the AG to give consent. Okay, what is the certiorari? What is mandamus? Okay, certiorari is an order where the court will quash, okay, the High Court will quash the decision of the public authority. Okay, quash means as if there was no such to cancel that order, to cancel the decision of the AG. Okay, mandamus, and then to direct AG. Okay, must give consent. Normally in judicial review, okay, you either want to quash the decision of the public authority, so you ask for an order for certiorari. Okay, a mandamus depends, okay, whether you are getting what you want to ask from the public authority. Okay, so next slide. Okay, what does Section 9 of the Government Proceedings Act 1973 states? Okay, that section says that AG, either AG or two or more persons with the consent of the AG may institute a suit for the purpose of, there are few purposes there, but the relevant will be B and C, okay? Either remove or appoint. So we know that if they wanted to appoint, okay, any new trustee or remove the existing trustee, you need to get the consent of the AG or two or more persons, okay? This is to file a suit, okay, to get an order from the court to appoint the new trustee or to remove the existing trustee. Okay, so next slide, please. So High Court's decision is that the association, in this case, for the judicial review, they relied on the ground of unreasonableness, okay, to apply for a judicial review. So it's the burden on proof is on the association to prove that the decision of the AG is unreasonable. Okay, before I move further, can anyone tell me what are the 4 grounds for judicial review? Okay, unreasonableness is one of the grounds. What are the 3 other grounds? Anyone want to try? Okay.
Is it that?
Yes, yes.
Procedural impropriety.
Yes, correct. That's one. 2 more.
Illegality.
Yes, correct. Another one, but very rarely used.
Can't think of the last one.
It's proportionality. Okay. So when you say unreasonableness, it means that the decision is so unreasonable, or other words, they call it irrationality. It is interchangeable. Okay. So unreasonableness in whose standard? Okay. Who say this is unreasonable? So the test is that they use the principle of Wensbury. Okay, that is the case, English case called the Wensbury unreasonableness. So you ask any sensible man, okay, they will give you the answer that it's unreasonable. Okay, so that's the principle of unreasonableness. Then illegality is where many other factors that can amount to illegality, such as whether the AG has taken into consideration irrelevant facts, or not taken into consideration relevant facts, or whether he exceeds his power, okay, which we call ultra vires, like what happened in the case of Ang Bing Lee, okay, where the controller exceeds his power, okay, that render his decision, okay, being set aside. And then judicial, procedural impropriety is where, yeah, it's supposed to follow, okay, certain procedure, but you didn't, okay, but the public authority didn't take into account. Let's say, do you hear both parties? Do you give a right to fair hearing, okay, to the other side, or you only hear one party? Okay, if it's proof that you only hear one party, then hear the other party, then that is it, procedural impropriety. That also grounds that happened in the case of Ang Bing Lee, okay, where judicial review was applied. Okay, proportionality is where it's more to like unfair dismissal cases, employment cases, where the decision maker, they makes the decision that does not justify the conduct, the misconduct, the wrongdoing. Okay, so that's a proportionality. So in this case, unreasonableness. Okay, so we focus on unreasonableness. So the court on the facts, okay, found that the association did not fulfill requirement of Section 9, which requires 2 or more persons to apply for the AG's consent. Okay, the association is 1 person or 2 or more persons. Don't have, right? So did not consult or obtain recommendations from the existing trustee to appoint the association as additional trustees. Okay, whether this recommendation thing, okay, it's not stated anywhere in the Trustees Act, but it was derived from a federal court decisions, okay, named Biku, okay, where the courts, okay, in considering whether to grant or not, okay, to appoint or not new trustee, the court will say that will see whether interests of the beneficiary will be conflicted, whether the appointment of this new trustee will support, okay, the objective of the trust. Okay, so this implies that, okay, the existing trustees' recommendation, or at least their consent, is needed, okay, for the courts to consider. So this actually association was filing this judicial review without consulting the existing trustee. Okay, so that was not correct, lah. All right. So this too provides the main reason for the AG's refusal, because there was no recommendation from the existing trustee. That's the main reason the AG's refused to give consent. All right. So the court found that in this case, the decision of AG was not unreasonable. That means it was reasonable. All right. Okay, next slide, please. So appeal, okay, the association. So association to trying to convince the Court of Appeal, so they raised these few things. The High Court failed to consider that the association had obtained funding to build pagoda, thereby fulfilling the wishes of the testator. The existing trustee and AG did not do anything. There was an entity who occupied the land, but AG did not do anything. Okay, so he said the inaction by AG was unreasonable. Okay, and then this indenture, okay, in the lower courts, okay, there was this recommendation by the existing trustee to be obtained, but still it doesn't oust the jurisdiction of the court to appoint trustee. That means, irregardless whether recommendation of existing trustee is obtained or not, the court still have the power to grant, appoint a new trustee pursuant to Section 45(1)(a) of the Trustees Act. Next slide. Okay, existing trustees had failed in their fiduciary duty because they do not fulfill the wishes of the testator. Supposed to build the pagoda, right? Okay, so therefore they must be removed. Okay, and few more grounds. Okay, appointing the association will not contravene the law of public charitable trust, because the trustee will still be bound by the terms of the trust. And on the requirement of 2 or more persons, association is comprised of 7 or more persons. Okay, that's what is interpreted under the Societies Act. Okay, association is a body that comprise 7 or more persons. Okay, so it has fulfilled the 2 or more persons requirement. And the AG misconstrue. Once consent, it means the AG agree to the association being appointed trustee. Okay, whereby the consent under Section 9 is merely consent to file proceeding, okay, not consent to association be appointed trustee. This is what was argued by the association. Yeah. Next slide. Okay, so the Court of Appeal here, after considering the facts, the argument, this was the decision, the conclusion. So AG's refusal was based on the failure of the association to obtain recommendation from the existing trustee. So therefore, the refusal was not unreasonable. Okay, so what I want to say is that the association failed to prove any unreasonableness on the part of the AG's refusal. All right, and then whether there's any misconduct by the existing trustee. They say existing trustee failed to, in their duty, right, to build the pagoda. But from the facts, actually, when it was in the High Court, okay, existing trustees were stopped from building the pagoda, from exercising their duty, because apparently there was various suits, okay, by other parties that prevents these trustees from exercising their duty. Okay, so there's no misconduct. Okay, so for the third reason is that a society can be a trustee of a public trust, but the trust land will be controlled by the society. Okay, society, the function of the society and the Societies Act is to benefit its members. The society has its members and not for the public, right? So while a trustee can, okay, there's nothing to stop a trustee being a society being a trustee, but the consequence there you have to consider. Okay, if a trustee, what happens if it can change its law, okay, to restrict the access to public? Okay, what happens if society later being wound up or bankrupt? Okay, what happened? So that's the risk. Okay, the other ground is that the AG has the power to protect charitable trusts. So if association is made the trustee, then the transfer of land would affect the charity funds. Okay, so in the hands of the society. Okay, so that's the, after considering all the facts, okay, the risk, okay, of being a society being made a trustee of a public trust. So the court upheld, okay, the decision of the High Court that the AG is reasonable in its decision to refuse consent. Okay, I'm not sure whether this case goes to federal court, but there's no record of it so far. Okay, probably will, right? But for the meantime, this is the decision. Okay, next slide. So in a judicial review, okay, as long as the AG or the public authority, okay, in this case where the judicial review was filed, as long as the AG or the public authority has exercised its discretion without any improper motive, okay, no mala fide, we call that, okay, bad faith, not taking into account irrelevant considerations, took into account relevant considerations, okay, has directed his mind in making the decision, okay, to issue the order that was subject to this judicial review, okay, and made the decision in accordance with the law on the statute, okay, then the court cannot interfere, okay, interfere those decisions. Okay, this is a general principle, okay, whoever authority, public body that file judicial review, the court will look at this, okay. They will not simply review decisions of the public authority, because in the big picture, you have to understand, judicial review in the big picture, what it means is that it's legislative, okay, you know there's 3 separation of powers in Malaysia, right? Legislative, executive, judiciary. So judicial review is one of the check and balance provided by the judiciary over the actions of executive. But it's supervisory, they don't take control of the AG's duty. Okay, so in that case, What it means is that, let's say, if a decision was quashed, let's say it's quashed the AG's decision, okay, the court doesn't substitute its decision, okay, it will not decide on behalf of the AG whether to give consent or not, okay. So in the judicial review, because it's only a supervisory power, you need to check the decision-making process, not the decision of the AG, correct or not. So it's the decision-making process, okay, that's the difference there, okay, judicial review and appeal. So let's say in this case, okay, the AG's decision was quashed. What the court will do is that the court will send back, okay, the matter to the AG, please reconsider, okay. So that's the principle in the judicial review, okay. All right, next slide. So the takeaway is that, okay, this is something new that under the Law of Societies Act and also public trust, okay, an association registered under Societies Act can be appointed as trustee of a public trust, but there will be risks that the association will restrict the use of trust properties to the benefit of its members only, instead of to the community, because the principle of a public trust is to benefit the community, right? Not members of the society. Okay. Okay. Next slide. Okay. Just some side note lah. If you see from the title of the case, okay, the suit was brought in the name of Chin Chi Kao, not under the name of the association, that long name, right? Okay, it is sued in as the secretary of the association. Why was this? Why we cannot put the name of the association? Okay, because of this, okay, Section 2 of the Societies Act defines that a society includes an association. Yes, it's not disputed. Okay, so and Section 9C of the Act says that a society may sue or be sued in the name of public officers. Okay, who are the public officers? Public officers are the name when you put in the registrar, okay, of societies, where in the event there's a suit, you will name that public officer. Okay, but if there's no such public officer being registered by the ROS, then you can sue in any of its office bearer. Okay, office bearer in this case will include a secretary. Normally will be president, okay, secretary, treasurer, but secretary lah, I see the most that they will put under the name of secretary. Okay, so this explains why this suit was brought under the name of Chin Chi Kao as secretary of the association. Okay, and not the name of the association itself. Okay, so this shows that association has to be sued or be sued through an agent, okay, pursuant to Section 9C of the Societies Act, right? Okay, I think that's it. Next slide. Okay, is there any question? Any comment? Sorry, I forgot to put my camera. Okay, next round will be corporate cases. Okay, it will be corporate cases. Any comment, any feedback, any questions, any clarifications? Welcome, Jun. Okay, if not, then I thank you for your attendance, and thank you for supporting the sessions. Okay, I hope that you benefit from the sessions. If any questions you want to ask later, also can. Okay, no problem. Oh, okay. Thank you, Ms. John. Thank you. Thank you. All right. Okay. Thank you for your attendance. I hope you enjoy the session again and benefit from this. Okay. Then I'll see you next round. Thank you.